Professionals Australia's briefing on the Secure Jobs, Better Pay amendments to the Fair Work Act, which were recently passed by the Federal Parliament. Before we start today's session, I'd like to acknowledge the traditional owners of the land on which we're meeting right across Australia and pay my respects to elders past, present and emerging, and extend that respect to Aboriginal and Torres Strait Islander peoples who may be joining us at today's webinar. My name is Jill McCabe and I'm the CEO of Professionals Australia. And we're absolutely delighted that the Secure Jobs, Better Pay amendments were recently enacted. Along with the ACTU and other unions, Professionals Australia and our members worked really hard to garner support for these critical reforms, which we believe will make the IR system fairer and far more accessible. We also think that the amendments will help us to achieve better paying conditions for our members, which I'm sure all of you will agree is critical. I'd now like to introduce Margaret Buchanan, Professionals Australia Director of Industrial Strategy and Workplace Advice. Margaret has many years of experience working in industrial relations, and she's a qualified lawyer. And many of you will know her if you've had to interact with Margaret's team in New South Wales and now nationally. So I'd now like to introduce Margaret, who will take us through the changes to the Fair Work Act as a result of Secure Jobs, Better Pay. Thank you, Margaret.
Thanks very much, Jill. Yes, most of you who know me already will have known me in my role as an industrial officer working in New South Wales with organisers and delegates and members in bargaining. This legislation does make some improvements in bargaining, which we'll be talking about today, as well as the aspects of the legislation which deal with gender equality and job security in broad terms there. If you had asked me when I came into this role a little over a year ago that we'd be in a position to be talking about improvements to the legislative framework before Christmas this year, I would have said, look, that would be wonderful, but I just can't see that happening. Legislation of this sort generally takes 6 months or more to get through Parliament. I think the fact that it has gotten through is due to a lot of factors, but not least being that the ACTU and Professionals Australia is part of that, really have known for some time what needs to change in the legislation. And that's based on the experience of our members. And so really, workers around Australia are going to get the benefit of this legislation. And if it weren't for union members such as yourself, that simply wouldn't be happening. So I think that's really important to recognise in this. So we'll start off with some of the material about bargaining that I think helps to put the legislation into some context and why improving the provisions of the Fair Work Act around bargaining is so important. So we've got to the point where it really is only 1 in 7 workers are covered by enterprise agreements, and the majority of enterprise agreements that are in force are well past their expiry dates. So they haven't been renegotiated for some time. At the same time, we know that collective bargaining makes a difference to people's pay. So in Australia, since 2012, real wages have increased by 9.1% for agreement employees compared to 1.4% for others. Now, I should say, if anyone's got any questions, please put them up in the chat. I won't be able to see that. I'll be counting on Jill to call out any questions. If they're related to what I'm talking about at the time, I'm very happy to answer them. Otherwise, if they're a little bit more off the immediate topic, we can come back to them at the end. And I should just mention as well that we did get some questions before the meeting today. Most of those tend to be either fairly workplace or sector specific. So I haven't really answered those. There were a couple of questions that have informed where I'll go with some of this. All of the questions that we received beforehand, by the way, related to bargaining, which I think is really interesting. So one of the reasons, well, let's look at why is bargaining hard. And if we're looking at purely from the legislative framework perspective, the Fair Work Act, as it has been applied and interpreted, has ended up favouring the employer fairly strongly. So getting an employer who has never bargained with their workforce before to the table is not simply a matter of a union going along and saying, look, do you want to bargain with us? They have to agree, is what the current situation has been. And if they don't agree, then it falls on to the union to get what's called a majority support petition together, where we can show that the majority of employees at that workplace want to have an enterprise agreement. And that can then be taken to the Fair Work Commission and have a determination made, which then obliges the employer to bargain. Now, while all that's going on, the whole arrangements around industrial action cannot occur until bargaining has formally commenced, and that there's been a genuine attempt to try to reach agreement. So industrial action is also very contained under the legislation. So there's very limited options as they currently stand to get things moving. And really, getting together majority support determinations is a lot of red tape to go through. Also, once you're at the table, the employer really can cross their arms and not reach agreement, provided they can say that they're genuinely considering what's being put forward. There's not much we can do in terms of taking them to the commission to get good faith bargaining orders, because the whole definition of good faith is about turning up to meetings, being able to show that you've genuinely considered what's being put forward, but there's no requirement to reach agreement. And there's also no mechanism in place for situations where bargaining can go on for years without resolution. As I've mentioned, now that has an impact when you have a lack of agreements. As I mentioned before, only 1 in 7 employees are covered by an agreement. Then that becomes the norm, is not having an agreement. So employers who are involved in bargaining therefore also take the approach that, in a way, they're doing a bit of a favour, because most employers don't have agreements. In some sectors, that's not the case, obviously. So when we're talking about hospitals, when we're talking about schools, most parts of the public sector, the electricity industry, and so on, then the norm is to have agreements. But outside of a fairly small range of sectors, the norm has become not to have an agreement. As I've mentioned, there is limits already on when industrial action can occur, and I haven't even gone into the whole process of having to have a secret ballot process that's conducted by the Electoral Commission or another ballot agent that's been approved by the Fair Work Commission. But another thing which many of our members caught up in bargaining have found is that when bargaining is going on for a long time, the next thing the employer often starts to talk about is threatening to terminate the current agreement. And that would then see the loss of a lot of terms and conditions that have been fought for over years to revert back to what award conditions are. And that has been a tactic, and it's been a tactic sanctioned by the Fair Work Commission as a reason for considering the termination of the current agreement. Meanwhile, we've seen, as a result of this real stagnation in bargaining, and equivalent stagnation in wages growth. And compared to other OECD countries that have 2 times higher the average wages growth than what's been in Australia. So one of the things that is changing is making access to multi-employer bargaining better. And one of the things that you would have seen in the being discussed as this legislation was going through was significant employer concerns about what multi-employer bargaining would mean. We've had multi-employer bargaining under the Act since the Fair Work Act was brought in 2009, but it hasn't been able to work. And there's a few reasons for that. But I think one of the first questions you have to ask about this sort of thing is, should workers have access to collective bargaining rather than being engaged exclusively on individual contracts? And if your view is that, well, look, collective bargaining is a right of workers, which is something that the International Labour Organization has established various conventions to which Australia is a signatory and so on, then you would accept that collective bargaining is, fairly an accepted norm generally in industrialised countries. Australia is fairly unique in that the focus of our collective bargaining has been at the enterprise level. So in other countries, we find that it's sector, industry, multi-employer bargaining that is fairly commonplace. But as with all things, when something like enterprise bargaining has become the norm, the thought that, oh, well, there's other sorts of bargaining are weird or way out and are going to see industrial mayhem, that's the kind of thing that the employer organisations have been running. It doesn't stack up against international experience. In fact, what is expected to occur with multi-employer bargaining is that, it will boost bargaining. And one of the reasons it does that is that it starts to take the employees' pay and conditions out of the competition between the employers. So you might have employers that are in the same sector who end up becoming covered by the same terms and conditions that apply to their workers, and that pay and conditions has been taken out of the competition. And that starts to have an impact on the use of casualisation, the use of outsourcing and so on, because it really is starting to provide a higher level of protection to the workers working in those sectors and industries. There's also sectors where single enterprise bargaining simply doesn't make sense. And that is particularly the case in areas like community services. So you've got government-funded organisations. They're not really in competition with anybody. Their productivity is more about what services they're providing to the community and so on. So then do you simply leave those people stranded on award conditions, which are set to be at the absolute minimum, or do you provide for a level of bargaining that again brings the government as the funder to the table to be involved in those discussions? So we are going to see changes, and the introduction of those changes will promote an environment that encourages multi-employer bargaining. It's not going to be available to employees if it's in the general building and construction industry. And that really relates to, there were significant concerns about how the impact that bargaining can have in that industry. If there are, things like there's been a history of wildcat strikes and so on. One of the questions I received before today was that someone had a friend who worked in that industry, was really concerned about employees downing tools. Well, multi-employer bargaining will not be available in this industry. And that is because of the enormous costs involved in, projects and how they're estimated and so on. If employees are already on an enterprise agreement and their employer's on an enterprise agreement, then they cannot become part of that multi-employer bargaining. It's possible, this is like looking into the future a bit, that there might be employees who are on an enterprise agreement that see a multi-employer bargain that's created, that think, look, that looks pretty good. We'd support that if our employer chose to go on to that when this one expires. We like the look of the pay rises. We like the look of the pay and conditions. We'd be happy to come under that agreement. And it is possible for that to occur where there is employer-employee agreement and otherwise. Multi-employer bargaining won't apply to small business. And again, I think that's partly because of immediately there is a lot of concern about this new thing called multi-employer bargaining and how that's going to affect people. And the small business representatives were very vocal and I think, influenced the view of David Pocock, the senator who was crucial to securing the passage of this legislation through the Senate to exempt small business from this multi-employer bargaining. Doesn't mean it will stay this way. A lot of what happens next will depend on literally how this legislation is applied and is undertaken. It does require majority support by employees. So it's not enough, for example, for a union to say, we're going to negotiate with this employer, with several employers, and the employers have no say in it. The employers can either agree. If they disagree, then it really falls onto the union to again obtain majority support, and that's not easy to do. But it is something, it's still available. Then the final thing that needs to happen is that there is a need to be able to show that there's a common interest. And again, you might have noticed in the media, there was a bit of discussion about, oh, well, this could be anybody, this could be, in a supermarket, Coles and Woolworths and everybody else, the clothes stores and chemists will all be in the same agreement. Well, no, not necessarily. If they've already got an enterprise agreement, they employ less than 20 people, they won't be part of that multi-employer agreement.
Margaret, it's Jill here. I'm just looking at some of the questions and there are a few that will relate to some of your other topics, but when it comes to majority support, would you be able to explain that to people, what we mean by majority support in relation to these multi-employer bargains? And also, could you please advise whether casuals and part-timers and contractors are covered by this legislation? Because there's, I think, quite a few independent contractors or people who are contractors that are participating today, and quite a few questions about what if they work for a labour hire or for an agency, or like a Hayes or whatever, and they're actually employed through Hayes to do work. So would they also be covered by these laws?
So with majority support, literally is whoever's on the books as an employee will count towards whether or not there has been a majority of everybody who's on the books who would like to have an enterprise and agreement. And typically what the process has been to have a petition, which could be online or in person, where an employee puts down their name, explains what their role is usually, and says that they would like to have an enterprise agreement along with all the other employees. That, when that goes to the Commission for determination, if that's required, we don't need to provide the names of the individuals to the employer. The Fair Work Commission goes through a process of saying to the union, who are those that you're representing? And says to the employer, and they don't have to be union members, although we need to have some union members there. They don't have to be union members to show majority support. It is majority support by employees. And then they'll ask the employer to put forward, provide them a list, which we don't see, of all employees. And so the Fair Work Commission plays a part in working out whether or not there is in fact majority support. In terms of contractors, fixed termers and labour hire, one of the things that, let's just start with casuals and part-timers and fixed termers. All agreements have a definition of who they cover and who they don't cover. And usually it's not by reference to whether someone's a casual employee or a part-time or fixed term employee. If you are a direct employee of the business, you'll be covered if your work is covered under the agreement. So let's say we're talking about, let's say any organisation, and it says all employees except the managing director are covered by this agreement. That's who's covered by it. Now, independent contractors or contractors labour hire are a different kettle of fish. They are directly employed by another, well, they could be employed in their own right as independent contractors, or if they're labour hire, they're a different category again. So we're talking about different categories. Independent contractors notionally would not come under this because they're not an employee, quite simply. Labour hire potentially could as an associated business, but that will depend on how the net is cast for the multi-employer bargaining. And one of the things I think, particularly with this part on bargaining that we're talking about now, something that all unions are engaged in and will be meeting to discuss later next year is what is our strategic approach to making the best use of this legislation so that we can start to provide the option of bargaining to workers across Australia. Now, that's a huge task, and we'll need to think about where we start, where we assist employees and so on. Now, that's not to say that employees can't just start doing some of this themselves, but it does require a level of logistics, I suggest, and a bit of thinking about, so what's the best way of ensuring there's agreement coverage of sectors that traditionally haven't been, or parts of sectors that traditionally haven't been. That's the kind of thing that I think unions really need to meet and talk about, because we'll need to work together. I mean, there's some organisations where Professionals Australia is the sole union, but more often than not, we're working, our members are working alongside union members from other unions. So this will also be not only multi-employer bargaining, but multi-union bargaining. And so to that extent, there is quite a bit of work to be done to work out where we're proceeding with all of this, particularly this is the mainstream change to the multi-employer bargaining. The next slide that I'll go to goes to a particular stream that we may well take an approach with a particular part of our membership. I'm not sure. It's hard to work out in this process whether or not I've covered that adequately.
Yeah, look, I think so, Margaret. I think I just preface my future comments by saying, please be aware that we'll also be running some more detailed sessions on each of these topics next year. So this session is really the overview of some of the key aspects of the legislation. As you're already hearing, it's quite complex. There are quite a number of considerations. So we may not get to everyone's individual questions today, but we can certainly answer them in subsequent sessions on each of these topics. There was one there, Margaret, which was about whether any of our members in architecture or engineering would be considered to be covered by building and construction in relation to multi-employer bargaining and therefore be excluded.
Yes, is the short answer. The long answer, though, there is a long answer though, because it all goes back to the General Building and Construction Award and the definition of what the work is that covers that. And that is, let me just say, a page long that we need to kind of decipher and work out who is within that and who isn't within it. But it can cover professional employees that are working in that industry or performing work in that industry.
Thanks, Margaret. And I think you've covered the other questions in general. We've got quite a few on pay secrecy, flexible work, and extensions of contracts by, again, recruitment agencies. So I know that the provisions around fixed term contracts no longer than 2 years, for example, but questions related to would that cover
so we've still got a fair bit to get through with bargaining before getting on to the other things.
Exactly. So I just wanted to let everyone know that we're watching your questions.
And it's complex, and if you kind of jump around, you really will just get lost.
Lost, indeed. Yeah. But be assured, everyone, we're getting to all your questions. So just please be patient with us. Thanks, Margaret.
So there's also a stream called the Supported Multi-Employer Bargaining stream. And this is one that we're looking at very closely in relation to our pharmacy members, because there are some, again, this is something that exists in the current legislation, but has proved far too onerous to actually get an authorisation. So the difference here mainly is that instead of having to get majority support for the employers that you're covering, you can apply to the Fair Work Commission for authorisation. There's also potential for the minister to declare sectors or industries that will come under this. But we would probably, I suggest, need to satisfy the minister on fairly rigorous grounds that A, this is a low paid area, relatively speaking. There's been a lack of history of bargaining, and there are vulnerabilities that are likely to prevent the uptake of multi-employer or enterprise bargaining unless this stream is utilised. So that's an area that we will be looking at closely for our memberships, particularly in those areas where we are lacking enterprise agreements. And there's no shortage of that, I must say. When you look at our membership, we're looking at around 50% are on enterprise agreements and 50% are not. So we've got a lot of work ahead of us on this. Now, let's look at what the actual changes to other than just the introduction of multi-employer bargaining. So this applies to enterprise agreements as well. So getting the employer to the table, if you're on an enterprise agreement that has expired within the past 5 years and there's no intention to change the scope of that agreement, then the union, by writing to the employer, can formally initiate bargaining. And the beauty of that, apart from just not having to go and get a majority support determination to force them there, is that if they don't come and start talking to us, we can go and get Fair Work Commission orders from about them being required to turn up, being required to have positions and being in a position to respond to us. Because one of the things that is really cruel bargaining over the last, particularly the last 5 to 6 years, is the length of time it takes to conclude a bargain. I think just about every bargaining I've been involved in recent years, getting anything done in less than 6 months is just heroic. It normally just takes 1 year plus. So I think that's one of the things that we really want to focus on, is that where we do have agreements and where we do have bargaining arrangements is getting them happening and getting them moving. Once they're at the table, there are changes to so that it will no longer be possible for an employer to kind of start idly talking about, well, perhaps we need to terminate the agreement. One of the major changes there is that it needs to be shown that the termination of the agreement is necessary for the viability of the business, and that even if it is terminated, and I really can't see it being terminated in many instances with these changes, that the employer must, that the legislation provides a guarantee that the redundancy benefits under those agreements stay in place for the next 4 years. So that then means that even if there is a termination agreement, because there's a viability of the business, and one of the things they need to be able to show is that if they don't do this, there's a real potential loss of jobs if they don't terminate the agreement. So I think they're really important changes. And our members who were involved in the Sydney Trains dispute quite recently, that the use of that threat there was something that came up before the minister and became, a factor in this. But it's been used. It was used at Ausgrid. It was used at Essential Energy. Just to name a couple of enterprise agreement negotiations I was involved in, and it had an absolute chilling effect on the negotiations and scared people. It was designed to scare people, and that kind of tactic of, ripping away the terms and conditions of employment of workers simply because they wish to renegotiate their terms and conditions is really, it's a bit of a shame on the system that it's been around for as long as it has. As I mentioned, there are limits on taking industrial action, and they're not changing. If anything, there is a new requirement that once there has been, so just for the benefit of those who may not have been through this side of things, is that, so you've got agreement negotiations going on, you've passed the nominal expiry date of the agreement, or it's a new agreement. In those circumstances, you can then ballot the members of a union as to whether or not they wish to take specific types of industrial action. And that ballot needs to be conducted, and it's overseen by the Fair Work Commission. So you apply to the Fair Work Commission, who authorise the ballot, which is then usually conducted by the Australian Electoral Commission, but you can apply to have a ballot agent conduct those ballots. So it is very formal. And once you have had a ballot, and provided that majority of the members who are eligible to vote support the various actions, you then have 30 days in which you're required to notify the industrial action, giving no less than 3 days, and it can be longer, to the employer. So there's quite a, you really have to jump through quite a few hoops to get to the point of taking industrial action. And then guess what? You can't take any industrial action if it's industrial action that might threaten the welfare of the community in some respect. And often our electricity distributor engineers find themselves in this situation. You can't actually take any action that will really bring things to a head, because then the action will be suspended or cancelled. So there are really incredible restrictions around industrial action, so much so that some people have said to me, all you really need to change under this legislation to sort out the problem with bargaining is loosen up industrial action. But as you can imagine, that would not probably get support through Parliament. I don't know, but that's another topic for another day. One of the things, though, is that multi-employer bargaining was excluded from taking industrial action. It will be available in multi-employer bargaining. The other major change, which will help, I think, in getting things moving, is that where there has been bargaining, or the nominal expiry date has elapsed by 9 months, that the parties have already been to conciliation processes at the Fair Work Commission, and there's no reasonable prospect of an agreement being reached, a party can apply to the Fair Work Commission to have the matters that remain in dispute arbitrated. So that will have means that instead of it just goes on and on and on, the parties have got nowhere to go, the Fair Work Commission actually does have the power to arbitrate the outcome of ongoing disputes. The Fair Work Commission doesn't necessarily automatically go into the arbitration. They might give the parties a further period to see if they can come up with any further agreements on some issues and not others, try and narrow the matters. Now, that doesn't come into place until probably June this year, but that will start to have an impact on the bargaining that we've got underway if we're aware of it and pointing it out that, you know, we need to get this sorted out. We'll be in a position to seek intractable bargaining orders if they don't get sorted out. So that should really provide a real incentive to bargaining. But having said all that, I don't want to make out that, oh, look, everything's been fixed with bargaining. It's still hard work. It's, you know, employers don't have to agree. We still may find ourselves having to run arbitrations. There still could be a lot for us to have to do there. So we'll obviously in the new year, we'll be taking a very close look on what the impact is of this across our union and where we need to be going. So that's the end of the section I have on the bargaining. Were there any other bargaining related questions, Jill?
Yes, look, there's just a couple, which is really about the employer size. So could an employer with less than 20 employees elect to join a multi-employer bargaining process?
Yes.
Great, so that's good. And then what if you work for a small business, it's got less than 30 employees and there's about 10 to 15 IT specialists in that business? Could they reach a multi-employer agreement with similar job roles in other companies just for them as specialist IT workers?
Yeah, I'm not quite sure what that, who are you employed by is the key question.
Yeah, so that's probably one that
kind of question that we would want to, you know, take as a request for advice, look at it and consider it. Yeah.
Yep. And then the other one,
there might be questions that people do have that do relate to your specific workplace. And I would suggest that you start sending them through to the workplace advice and support area. And that'll be helpful for us because it will help myself and others start thinking about, so what sort of advice do we need to be getting out generally to members about this sort of thing? And what kind of level of advice and support are we in a position to be offering around all of this? Because, I mean, I don't expect there will be an explosion of bargaining. If anything, what I expect is most likely to happen is that an employer who doesn't want to be caught up in multi-employer bargaining might come along to its workforce in the next couple of months or so before June and say, look, here's an agreement. This kind of covers us all off and we won't have to worry about multi-employer bargaining. You know, let me know if you support it and we'll register this. And in those circumstances, we really would like, you know, members to, you know, get in touch, get out, you know, make the most of your union and the advice you can get about what is being proposed to you by your employer. And deciding whether or not that is a good deal for you, because we're in a very dynamic situation with the way inflation is running and pay rates are working. We're already seeing significant information starting to come through from the Fair Work Commission about what the average pay increase is. And at the moment with enterprise agreements, the annual it bounces around a fair bit from week to week because that's how frequently they're putting it out, but it's generally got at least a 3 in front of it. And what I mean is, so like a 3.5% pay increase is not unusual at the moment, and that's a jump from a typical pay increase of 2.5%. That's just your annual pay increase, so it just goes on top of it. It doesn't reflect, you know, changes to role pay increases or anything like that. So there's a lot going on in that space that I just would like people to be aware of.
And look, just one more question, Margaret, and this one might have to be taken to our to Nikki Barris to respond to, but I noticed that there's quite a few questions from translators and interpreters wanting to know whether this legislation will actually assist them, given some of the issues that have occurred with, you know, award coverage for them, many of them being contractors. So do you see opportunities for better paying conditions under this legislation for our TIs in the future?
Yes, I think so. I mean, and I'm saying that from the perspective of this is going to normalise bargaining. This legislation is going to play a really critical role in it being, instead of employers seeing bargaining as too hard and messy and everything else, is seeing it as, no, this is something that can be done and it's achievable, and our workforce is happier when they have enterprise bargaining than when they don't. And they actually talk to us and tell us what they think when we have enterprise bargaining, and they don't otherwise. So I think it has got the potential to change the whole culture around bargaining. And even if there might be some legal barriers at the moment, because technically you're an independent contractor, well, there might be ways by which, you know, the employers will come to you and say, would you like to be an employee? This is what we're looking at, you know. So those sorts of things are likely to change the environment we're in. And that's what good legislation does. It changes what the default is, rather than just keeps things as they are, which are not working for workers in Australia at the moment.
Thanks, Margaret. I think they're the main questions on bargaining, so we'll let you get into the next section. Thank you.
Okay. So, end of pay secrecy. And this is, for the last section, that would have been of particular interest to everyone, whether you're on an agreement or not. This one will have more direct relevance for those who are on common law employment contracts, so not on agreements, because generally I can't recall any of our agreements prohibiting members from discussing their pay with others. However, in the take it or leave it style of bargaining that applies to most employment contracts, here's the contract, sign here. I mean, there might be an opportunity to come back and say, look, I've got a concern about this clause, but pretty rare in our experience that employers actually change it. And that's become even more so in recent years. And I wouldn't be surprised that some of this changes with bargaining will see a better approach, a more sort of employee-focused approach in contract negotiations as well. Because again, it starts to shift what the expectations are for everybody about where it should be. But what I can say from the work of the Workplace Advice Service, which does the contract reviews, is that almost without exception, the private sector workplaces that have common law employment contracts generally have a clause in the contract saying that the employer agrees not to discuss their pay with anyone other than their legal or financial advisors. So that's the current situation. From 7th of December, employers are now prohibited, and it's a civil penalty, if they enter into contracts that have such clauses in them. With existing contracts, what happens there is that they will still continue to apply. So if you have an existing contract that says you're obliged to observe pay secrecy, that still applies. Now, this change was made partly because of the incredible number of employees are covered by common law contracts generally, like it is, you know, if 1 in 7 are covered by agreements, that generally means the rest are covered by contracts. The degree of detail will vary, but that is to give you an idea of just how widespread it is. And I don't think I'm telling you anything you don't already know, which is that if you can't ask someone who does the same work as you, what are they getting paid, how that affects you when you're having a pay negotiation or discussion even with your employer. I mean, if you don't know that that person that does similar work to you earns $20,000 more than you, then that's going to affect your bargaining position, isn't it? It's the same thing. You need that transparency to know whether or not your pay is fair in relative terms, as well as what you might think you're worth. So that's a major change that's happening there. I will say to you quite openly, I'm not quite sure why the law wasn't changed so that existing contractual provisions are deemed to be void. I can't answer you that question. What I can say is that employers have been given until the end of this year, I think it is, it's either 6 months or the end of this year to make the changes to their contracts. So even if they enter into a contract that has got one of these pay secrecy clauses in it, that won't have any force. They won't be penalised for that for the first 6 months or 12 months, I forget which it is. After that, it will be a civil penalty. Now, because of that staged aspect of it, where you'll have some employees, new employees, who have contracts without pay secrecy provisions, and other employees that do have pay secrecy provisions in their contracts that still do apply, it makes it difficult to still go in and have a discussion. And one of the things we want to get some advice to members about is, well, given that complexity to the situation, what can I do? And it's something that I think we need to give some thought to before we actually put in writing what our advice would be about how to approach that. The important thing is that you're not bound by it if you enter into a contract after 7th of December to any pay secrecy, and that you can talk about your pay. And that is a first start to being in a better position to knowing what your pay is. But I'm going to put a plug in for bargaining at this point, because with bargaining, one of the things that you can do as a where you're doing enterprise or multi-employer bargaining, one of the things you can do, and the employer is required to provide it, is to ask for, well, what are the ranges of pay that apply to various positions in an organisation? And the employer, as part of their duty to provide, to respond to information requests that are relevant to the bargaining, is required to provide that information. If they don't, it's possible to seek a Fair Work Commission order that requires them to. Generally, you don't have to go and get that order unless they want to, play in semantics about what they can and can't, what they are and aren't required to provide. But it's worth remembering that bargaining still provides a level of transparency just by having it start in your organisation than continuing on contracts. That's all I wanted to say about the pay secrecy. Is there anything?
Margaret, I think you've covered the question about when does that when do the clauses no longer have effect, because we did have one of our members or one of our participants asking about existing contracts that already contain those clauses. So I think you've responded to that. The other question was, is there any ability to ascertain what a contractor, again through a recruitment agency or a labour hire company, is earning compared to you as a direct employee? Whether the removal of pay secrecy extends as far as others that are brought into the organisation, but they're essentially working through, again, a Hays or another company.
So, yeah, that's a really good question, because the thing about these provisions, it gives the individual employee a right to disclose or not to disclose. It doesn't give put an obligation on others to disclose their pay or their remuneration. And yeah, so that's an excellent question to understand that distinction. Again, this is like a first step in the right direction. Ideally, there will be a level of much greater transparency. And what I understand, and we haven't talked about this is not the end of the industrial legislation. There is intended to be further legislative proposals, and those legislative proposals will be looking at ensuring, well, there is equal remuneration depending on whatever form of engagement it is, whether it is an independent contractor or so on. But obviously there's complexities to that, because as independent contractors, you don't necessarily have the same security of employment as others do. And so how do you sort of assess that, and how do you determine the circumstances? When we get a bit more to job security, we'll touch on that a bit further. But yeah, I might just
that's great. Yep.
For now. Yep.
Thanks, Margaret.
So request to work flexibly. This already exists as a national employment standard. So as employees, you have a right to request flexible working arrangements if you are in one of a number of groups. And those groups include anyone who is 55 years or older, anyone who has a disability, anyone who has school-age children and the parent of that child, and so on. And I've given there some examples. It could be that you're working from home, you're working reduced hours, working outside of the usual span of hours, or you're working compressed hours. So for what I mean by compressed hours, so we have some members who work what's called a 9-day fortnight, where they work their weekly 10 days hours across a 9-day period. And that's much loved by those who enjoy that arrangement. In the parts of the public service, there's also flexi time that operates separately to this. So this would be where flexi time doesn't really work sufficiently for you. You still have a right to request to work flexibly if you're within one of those groups. Now, those groups have been expanded to include someone who's pregnant. It's surprising, isn't it, that as a pregnant woman, you didn't have a right to request that already. And if you or a member of your household are caught up in a domestic violence situation, flexible working arrangements may be one of the measures that will add to your safety. The refusal is by the employer to such requests is based on whether or not there are reasonable business grounds. And these haven't really changed, but there is more of an outline in the legislation of what the employer is required to do and what reasonable business grounds are. So the employer, it's now specified that employer is obliged to discuss the request with the employee. The reasons, if they refuse, must be put in writing. And a new requirement, though, is the employer must also let the employee know if there are other ways that could possibly assist them with what they require the more flexible working hours for. The reasonable business grounds are generally around, will it be too costly, or there's no capacity to change the working arrangements of other employees, or it's impractical, likely to result in a significant loss in efficiency or productivity. The major change, though, is that previously you could make a request, and if the employer refused, that was pretty much the end of it, unless you had an enterprise agreement provision that made specific that you could have the matter arbitrated by the Fair Work Commission. Now, the ability to have the requests conciliated and arbitrated by the Fair Work Commission is now coming into the legal system, and that will have a number of benefits. Firstly, just having that puts more of an onus on employers to go through the processes fairly rigorously, do it properly, not just say, well, we've considered it and no, we can't, sorry, we can't accommodate it. It does up the ante on employers to really give it a fair consideration. I'm not saying all employers haven't, but it will just have that effect. And it also means that we will get a bit more of an elucidation of, well, what does reasonable business reasons mean? Because that will be the sort of thing that the Fair Work Commission will be looking at and giving its consideration of and outlining in more detail. And we'll start to see some decisions on that. So that will hopefully make that something that is more enforceable than it has been. And just on that, like, I understand a lot of members have been enjoying the ability to work from home. Most of that, of course, has been with the employer's sanction, not requiring specific individual arrangements to be approved. What I'm talking about here is having a formally recognised flexible working arrangements that is reduced to writing. It is an agreement, and it means that you've got that security of mind that is occurring. Now, I did think it might be something that, and we'll come to this at the end, this might be something that our members, particularly if they come with any of those groups, would like to explore further to get that kind of peace of mind. And we could probably run a session specifically on how to go about doing this for members if you were interested, but we'll come to that a little bit later.
Just on that, Margaret, there's just a couple of questions around, again, the criteria for your flexible work request around, is it limited to people with children of a certain age?
School age children.
So is that anyone up to 8, secondary school as well as primary school?
So the kids are at school. Great.
So that covers that area. And then the other one was around people being able to work from home, because we've had a question around people worked from home during the pandemic and want to continue, but are now facing pressure in some workplaces to return. So I think that working from home was one of the options. Is that right?
Yes.
Yep.
Yeah.
So that would be covered by this.
Exactly. I mean,
yep.
Yeah, I think it would be valuable to have a separate session on this,
yep.
because we
right.
could explore a bit more about, okay, so people have been working from home, you know, what are the reasons for continuing to work at home for particular individuals in those groups? That would be
great.
And so on. So there is a bit, I think, to unpack there.
Excellent. But I think we've covered those questions. So thanks, Margaret.
No problem. So now we're going to look at the elements of the legislation that are concerned with gender equality, and I think we need to kind of just think about, well, why are we looking at gender equality in 2022 in legislation? Hasn't the legislation already dealt with that over the years? And I think the thing that's important to understand is that one of the things that has deeply informed the way work is organised, whether it's the areas of work that we're in, the prevailing work conditions, even the kind of educational opportunities, that has been informed, particularly in the past, by traditional concepts as to, well, what is women's work, what is suitable for women to do or men to do. And in terms of prevailing working conditions, it's been built around this idea that the worker is a full-time worker with there's someone else looking after the caring responsibilities. And that doesn't really reflect what the situation is for most of us, whatever our gender is these days. We'll find that, men want to be involved in childcare and have access to parental leave. We'll find that men will also want to be involved in other carer aspects of life, such as with elderly parents. So the sort of things we've been talking about with pay secrecy and requests for flexible work, they're sort of examples of improvements that are actually made in support of gender equality, because it is seen that, that without those sorts of changes, the wages gap for women will continue to be significant. It's the latest figures, if anything, are getting worse again. And the request for flexible work, which is really recognising that people, we're more than workers. We have other parts of our lives that involve important commitments that we need to meet, that those flexible work aspects are also recognising as the worker. It's not just the male breadwinner style, which is fairly dated. But it's not really in workers' interest that we don't have access to various sorts of working conditions that recognise that we're human beings. So the sorts of things that are also being done in the name of gender equality, but I think we will find have a potential to assist all of us as workers, is that the objects of the Act are going to include both gender equality and job security. Previously, it was based on a fair remuneration. So it was limited to fair remuneration. And so it's one of the reasons why the domestic violence leave provisions took forever to actually be done through eventually in legislation. Because the Fair Work Commission didn't see itself as having the power to make paid leave available for those experiencing domestic violence because of the way the object was worded. The new legislation also improves the right to request extensions of unpaid parental leave. So it was much more at the employer's discretion if you had wanted an extension of your unpaid parental leave. Remember, under the legislation, it can be for up to 2 years. If it's a couple, that the 2 years is shared between the two people. But it is up to 2 years that people can request extensions, and your rights, if you're relying on unpaid parental leave, and this is very relevant for casual workers, was very circumscribed and really much at the discretion of the employer. The legislation prohibits sexual harassment, and what that means is that sexual harassment is already recognised under the various anti-discrimination laws, but there will be a dispute resolution procedure that will also, at the moment, there's what's called stop harassment orders. Often where we've had members come to us seeking this sort of thing, the harassment's usually ended, and the only option under the Fair Work Act has been stop harassment orders. The new arrangements provide for compensation, and it becomes an obligation of the employer, a positive obligation on the employer to take measures to prohibit and make clear that what is sexual harassment, and to make clear to workers and others who come into the environment. This is one that does affect independent contractors, that there's certain conduct that's not acceptable. Now, similarly, under the Fair Work Act, we already have what are called attributes such as race, sex, sexual orientation, age, physical or mental disability, marital status, family or carers' responsibilities, religion, political opinion. They're all protected attributes that you cannot be discriminated against under in your employment. And added to those will be breastfeeding, gender identity, and intersex status. And that is really doing no more than aligning with the anti-discrimination provisions under other law. And there'll also be a recognition when it comes to work value cases. Now, work value cases, some of you may have never heard of what a work value case, what's that? They occur under the various modern awards, where you're looking at the pay rates that have been struck under the awards, and you can look at, well, does this pay rate as a minimum reflect, when you look at the pay rates in other awards, what the minimum should be, or should it be increased because there's been changes to the role or so on. And we're actually got one of those cases on at the moment for our intern pharmacists. Now, one of the new factors that is getting specific recognition in the legislation is that has there been historic gender bias in how this particular type of work has been valued? And so that will be another consideration that can go towards improving pay, which is only a positive, I think. So that was pretty much on the gender equality questions. And so now we get to the job security. As I've mentioned, job security is a specific purpose of the Act. So that means that when the Commission is exercising its powers, whether it's with agreements or with awards and so on, it needs to be looking at, well, how will this affect job security? Is it likely to improve job security or not? And that becomes a relevant factor in weighing things up. I should mention that the Fair Work Commission is probably got about 20 different objects that it's working with. And it will also weighs up, what is the likely impact on a business? So it's not just workers' interests that are reflected in those objects, but also employer interests and the broader economy as well. But that is an important one, and it's one that is these two areas, job security and gender equality. I think the last 10 years, we've really seen a lot being talked about where these things need to be improved, that we seem to be going backwards or not making the improvements we might expect. Like I've mentioned, when it comes to terminating an agreement, there must be a guarantee of redundancy arrangements. And there also will be limiting the use of fixed term contracts. So currently, someone could enter, there's no limit on how long a fixed term contract can be struck for. But under this legislation, which will not come into force probably until the end of this year, and again, it's because of the complexities once you start applying it to particular workplaces and types of work and so on, it's actually not coming into force until the end of the year. So 2 years will be the permitted length of a fixed term contract. And that would apply also where there's been consecutive contracts. So if you've had a series of contracts that add up to 2 years, then that's the maximum it would go once this comes into being. There is also a series of exemptions, and some of those exemptions are likely to catch our members because specialist work is one of those areas that can be caught. If it's clearly an identifiable project, that will come into play as well. So there will be a fair bit of time for us to really get right across how this will apply to our memberships, but it is worth noting that this is one of the first steps, major steps, I think, that the government has taken on this area. Now, with casual workers, you might recall that there was a High Court decision earlier this year that said what is decided at the time of engagement is the nature of the employment. If it's casual, that will then remain what the employment is, and nothing further will be looked at in terms of what actually occurs in the employment relationship. So there is a need to legislate what is a casual worker, because we're now dealing with a High Court decision that says essentially if the employer calls you a casual at the start of employment, that's what you're going to be, and we're not going to look any further. Whereas often it's not uncommon for something to start off as casual employment and it kind of morphs into something else without anything in writing, but you are expected to be there every week and it goes on for years. That's not so much in our membership areas. That tends to be more in the unskilled areas. But even so, it's an issue that is a concern, because what is occurring in one area affects expectations about what can occur in other areas. Similarly with labour hire workers, there's a look at, apart from defining, making clear that a casual worker is someone that does not have an expectation of continuing employment. With labour hire workers, what needs to be looked at there is about, well, what are the conditions, terms and conditions of employment. So the pay comes into it, but also the terms and conditions of employment. So you can have a situation, I was reading about one just recently where a warehouse was closing. The majority of workers there were casual employees. So as casual employees, they had no rights to redundancy. There's also a small group of ongoing workers. They had pretty good redundancy rights, 4 weeks for every year of service. And then we had labour hire workers that didn't have any rights either. And so what the union did in that situation was to negotiate an enterprise agreement that provided for casual workers to be converted to ongoing workers and to have those rights, and for the labour hire workers to similarly, if they wish, to be converted to as employees and to have the redundancy rights as well. Didn't save their jobs, which is what job security should be about, but it did mean that they at least had access to similar redundancy conditions, same redundancy conditions. This is going to be a very politicised area when it comes up in the next tranche. And I think it's important to remember that this legislation that got through was really what needed, there needed to be changes in some of these core areas. And as we saw, there was a fair bit of protests. It never really snowballed into very much because some of the claims being made about what was wrong with it was simply false. Small business wasn't getting caught up in multi-employer bargaining if it didn't want to be. There wasn't going to be a right to just take industrial action no matter what occurred. But we will be moving into areas where there will be, I think, a real contested debate about what the rights of workers will be and what employer obligations should be. And not least will be this area of, Australia has seen a real proliferation of what we call insecure work, whether it's casual workers, people working in the gig economy, and labour hire workers in particular, and also independent contractors too. And that area, if it's going to be significantly changed, obviously there's winners and losers. That's one of the things about industrial relations. There tends to be winners and losers. Where we're arguing for what's fair and what's reasonable, there's a pretty good chance we'll win. But that's something that we will see, I think, in the 2023 when that legislation comes through. So when it starts coming through, we will probably need to be thinking about how we deal with any misrepresentations about what that legislation is doing or could do if we want to see more fundamental changes made to the industrial relations system. So that was pretty much it.
Margaret, I've just got, yeah, thank you for that. There's just a couple of questions around, and I appreciate that we've probably got some, as you said, further changes that might be coming into this area around casuals and labour hire. But just the exemption that exists in relation to fixed term contracts being exempt where they're tied to government funding and grants. Are we able to provide any further information about that at this stage, or is that, again, another question that we'll need to delve into more deeply into the future?
Look, it'd just be off the top of my head, and I think that's the sort of thing, again, that we need to unpack the specifics to really be very valuable. Yeah. Yep,
no worries. And clearly, one of the issues that's been raised, and I was aware of this when I was in the public sector, that there were many workers who'd been on a number of fixed term contracts for many, many years, and probably had around 20 years of service, but all on fixed term contracts. So I'm sure that this legislation is designed to deal with those sorts of issues. So again, we'll be delving into this topic in more detail into the future. So oh, thank you. And look, I do want to thank everyone for attending today, but I also want to thank Margaret Buchanan, who's done a huge amount of work in helping PA understand the legislation, support the legislation, and now give effect to the legislation. So thank you, Margaret. I'd also want to thank Emma Kemery and also Mandy Gervin from our comms team, who have assisted in delivering today's presentation. So thank you for that. And as I said, we're going to be running further sessions in the next 6 months on particular topic areas. And we do think that this legislation provides us with leverage to really represent our members more strongly, and also to secure better pay and conditions. So encourage you to remain engaged with us, stay connected, and we will be sending this slide pack out to all the participants today. So you will get a copy of this, and you'll also get some follow-up information about further sessions. So thank you, Margaret. I don't know if there's anything else you wanted to say to today's participants about your understanding of the legislation and where it's all going, and what you think the future is going to look like.
Oh, thanks very much, Jill. Look, I'm really looking forward to next year. I just feel like we've got something to work with at last. It's been quite a tough gig, I've got to say, for our members over the past few years, and I'm really quite excited about what we could achieve under this new legislation. And I apologise for going over time, but I hope it's been worth it. So, and please have a wonderful festive season.
Thanks, Margaret, and thanks to everyone else, and thanks, Emma, and also Mandy. We'll see you at our next webinar. See you later, everyone. All the best.
Bye.